This test of life is a collective one. There's no isolated incident under any circumstance. An example of this is certain cultures in other parts of the world where when certain people pass away, despite the body being taken care of, the spirit still has to be collected. The spirit did not depart the body in a place of comfort or at home. The spirit has to be collected at that site where it's separated from the body and then brought back home so that it can be invoked by the next generations. Otherwise, that spirit, that location where it departed with the body, if it's not properly collected by its loved ones, not the physical body, but the spirit itself, it would perpetuate that same occurrence and make things worse. That's why oftentimes if you see an accident scene at a main road, there's going to be other consistent pattern of that same thing happening, or similitude of haunted houses and things like that. That's because the spirits there were not properly collected by their loved ones. Believe it or not, that same principle applies when it comes to learning about law and the operation of law, which is the legal aspect. The different types of laws, the different types of principles behind those specific types of laws. What you and I are doing today has a specific spirit attached to it. It's a type of collective consciousness that everyone has to play their role in it, regardless of what culture you think you are, regardless of what organization you think you belong to, regardless of what status you're claiming to be. If you and I don't give the spirit of the law the proper attention that it needs today, it will speak up for itself tomorrow by making the future generation hurt and suffer. Just like we are seeing right now, there were certain things that the previous generation before us failed to do that you and I are suffering from now. And that is because the previous generation failed to pay the proper attention to collect the spirit of the law, nurture it, and put it to use properly. The spirit of the law itself wants that attention. And ultimately, when that attention is given to it, we naturally benefit from it. Otherwise, it will look for every way to express itself, every way to speak up for itself. And one of those symptoms of the spirit of the law speaking up for itself is the suffrage of people, the inequity, the unjust nature of everyday activity, whether it's financially, physically, emotionally, parents being taken into mental hospitals as a means to strip them away from their children, people's substantive right to be able to defend themselves by bearing arms and having a well-regulated militia. It's been taken advantage of. People are being thrown in jail for 25, 50 years for simply having the right to bear arms. A basic and simple necessary things. People who engage in religious sacraments, rites, and other spiritual activities are not able to use it anymore, to the point where the realm of using certain herbs have been locked down so much and limited to a certain corporate commercial interest. The essence that people will use on a spiritual level through those herbs are eliminated in laboratories, and the ones that dumb you down are sold in the public. They kill two birds in one stone, on a spiritual level and on a financial level, for many people. And then it goes on and on. People can't go down the street in their private properties, or at least what they think is their private properties, without the fear of being stopped and taken advantage of. And then it goes on and on. These little symptoms that we all see and experience every day. Most people make just enough just to pay bills. Those are symptoms of the spirit of the law itself speaking up, because we've slept on it. If you are really serious about solution beyond speculation, beyond some intellectual masturbation, then you would understand that there is a collective consciousness involved in knowing the subtle substance of things. The subtle substance that an acting judge or anyone that you are suing or is being sued, whether it's privately or publicly, even if there's no formality of docket, these subtle substances are always at play. And just as somebody is not telling other people in other culture that whenever a spirit separates from the body, they have to collect that spirit just as much as they collected that physical body before burying it, so that that spirit can be conjured by the family for protection, wealth, and good fortune, so that that spirit does not go around to and fro from earth seeking to devour others because it has been abandoned. The same apply with spirit of the law. This thing called law, whether it's commercial law, natural law, ecclesiastic law, man-made law, private law, administrative law, the blanket of law, that thing that causes people to act and perform based on value and consideration, that thing has its own active sentient intelligence. And that active and sentient intelligence would drive the everyday man mad if they don't understand it, just as much as these spirits affect people without them realizing it. It is your responsibility and my responsibility to collect the intent and the spirit of the law, acknowledge it, respect it, and put it to use. And one of those things that many of us have forgotten or lost, no matter who we think we are, no matter who we think we're affiliated with, no matter how special we think we are, the spirit of the law is always going to be uniform. No matter what type of law it is, certain foundational principle is necessary. So you say you want to have a trust, administer your own private estate. You say you want to sue someone personally, right? Or somebody is probably going to affect you in the future and you want to hold them liable. Or it has already occurred. Your children were taken from you. You're trying to get them back. You're trying to hold people liable. You're trying to get recourse in a beneficial manner. And you're trying to abate things that are not beneficial to you. Here's one other foundational principle you need to put into consideration. One of those spirits of law and the principles of law is a doctrine called Respondeat Superior. The operation of law involved principles and doctrines. Those doctrines and principles are the vehicle, are the means to which that vehicle functions. A vehicle called law, whatever type of law. This applies in all hierarchy and all levels. The doctrine of Respondeat Superior. A legal doctrine most commonly used in tort that holds an employer or principal legally responsible for the wrongful act of an employee or agent. If such acts occur within the scope of the employment or agency. Let's stop there for a moment. A mouthful was said. Legal is the operation of law. Doctrine is a standard or a principle. Most commonly meaning based on general law, not special law. Special law are private laws like IRS codes. Commonly means common law, meaning if you cross-reference this principle with your state laws, it would perfectly align with the Constitution of the state and the Constitution on a federal level. And that doctrine and operation of law that's backed by common law applies in tort. Tort, in short, is the act of you holding someone liable based on the act that was performed against you to your detriment. Tort is a short word for torture. Tort is a type of law whereby people are held liable for a torturous act towards you. And that involves all the previous things I've mentioned. The child being taken away, someone keeping you in jail for a traffic infraction, someone not having probable cause or a warrant, you being thrown in jail because of your Second Amendment right to firearm, you not being afforded due process, the court being prolonged for years after years because they want you to get an attorney, them doing a psychological evaluation on you despite you having no previous medical history when it comes to the mind or mental health problems, etc., etc. The list goes almost infinitely. The foundational principle in common law for holding people liable. What people? The employer or principal that's legally responsible for the act of employee or agent. The owner that hires other people, and those other people are the ones damaging you. The peons, the little cops, the clerk, the child support agencies, the employees. These people know no better. So now they've harmed you out of their ignorance or willingness to hurt you, because some of these people do it knowingly and willingly. There will come a point where it's not really the subject matter or the principles that you deal with when you deal with peons. It's the different personalities. And different personalities are that of people who they themselves have mental health problems, that have childhood issues, that they're trying to compensate with a position in society by taking advantage of others. Or it's just the culture and the working environment. And they have been conditioned to treat people a certain way because that's the fastest and quickest way to make money. Fear and control makes money, whether in the ancient world or in the modern world. And those agents, whether they be employees or subcontractors, are 9 out of 10 times those that the general public interface with, and not the CEO. And Respondeat Superior is basically telling you, within the operation of law, to hold people liable for harm done towards you. There is a doctrine and a principle whereby you can hold the head honcho liable for the acts of the peons, so long as that peon is claiming to act under their scope of employment or agency. See this last few terms, if such act occur within the scope of the employment or agency. This is what acting under color of law means, aka color of authority. Whenever tort is engaged in, it's up to you to now discern whether you want to hold the personal man liable or you want to hold the entity liable. Tort is so broad that it allows you the opportunity to function either on a commercial level or on a natural level, meaning the natural man or woman. And if you play your cards right, if you follow other foundational principles, then your best bet will be to go after the private man. A lot of people talk about their functioning under color of authority, under color of law. If you don't understand Respondeat Superior, sorry to break your bubble again, all those are just another cute sounding words that you're just throwing out there. You're wasting valuable time of your life just going around in a circle. 10 years will go by, 5 years will go by, 2 years will go by. And who have you held liable? And how have you come together with others to hold these people that you hate so much liable? You would have nothing to show for it. Or at least, how have you alleviated yourself of liabilities to set up to hold people liable? When you understand the dynamics and comprehend and become savvy to the dynamics of those buzzwords, you will see them everywhere without the actual buzzword. This last highlighted sentence, if such act occur within the scope of the employment or agency, you would know that that basically is telling you under color of law and under color of authority. So what is color of law, or what is color of authority? We can go to American jurisprudence to explain that, but I'm well aware that the majority of the people that are most likely going to see this video are still in the basic stages of using Black's Law Dictionary, which is good. And by the way, Black's Law Dictionary, or any law dictionary for that matter, are best to be used to cross-reference certain case laws. We'll talk about that in the future, but let's not deviate too far. But let's go to what most people are comfortable and familiar with. Let's go there and give it to them from that angle, and slowly we'll move upward. According to Black's Law Dictionary, page 278, we know colorable means a semblance, something that's not true. Color of law: the appearance or semblance without the substance of legal right, meaning they're outside of their capacity to have judicial immunity. Misuse of power, possessed by virtue of state law, meaning they're saying because of this we can do this, but in truth that supposition of law, power, authority did not grant them the ability to take your children, did not grant them the ability to arrest you, did not grant them the ability to take your house, did not grant them the ability to take your paycheck, your pay stub, or anything valuable away from you, which can also be your rights. It doesn't have to be something you can physically touch. And made possible only because wrongdoer is clothed with the authority of state, Meaning they're saying because of this, we are the police department, we are this agency, we are that agency. Remember, Respondeat Superior talks about if such an act occurred within the scope of the employment or agency, right? And because we are this agency or this entity, we are doing this to you. Misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state is action taken under color of state law. It then goes on to say, acts under color of law of a state include not only acts done by state officials within the bounds or limits of their lawful authority, but also acts done without and beyond the bounds of their lawful authority. In order for a lawful act of an official to be done under color of any law, state or federal, the unlawful acts must be done while such official is purporting, and they're pretending, or they're claiming, or pretending to act in the performance of his official duties. In other words, all that legalese is saying somebody used the prestige of a capacity to do an act that is not authorized. So you see now that Respondeat Superior directly deals with color of law and color of authority. When you want to invoke any type of right and you want to hold anyone liable, whether it's an act that's done in one venue or another, you must invoke Respondeat Superior. If you do not invoke this doctrine, they will throw you the brick of 12b-6 and pair that up with judicial immunity. Typically, when Respondeat Superior is invoked, a plaintiff, in this case, let's say you, because you are the one now going at it with them, will look to hold both the employer and employee liable. Remember, if they were acting under color of law and authority, that means they're letting you know, despite the fact that this website tells you employer and employee liable, you need to hold them personally liable, the CEO and the man who interfaced with you. Everyone gets it. As such, a court will generally look to the doctrine of joint and severe liability when assigning damages. Now, just like there's court tests and control tests when it comes to the jurisdiction of a trust and whether a court has ability to adjudicate its interest, well, most doctrines usually have tests. So in order for you to properly invoke the doctrine of Respondeat Superior, you will be tested. They will not invoke these words against you, which is benefit tests and characteristic tests. But the dynamics of it will be used against you. So if you are looking for these buzzwords, don't expect it. But the dynamics will be performed so swiftly. For instance, any sports, whether it's martial arts or other type of entertainment sports, football, baseball, the man or woman practices certain moves over and over and over and over to the point where when they eventually perform it, it looks so quick and so swift. And it's performed within a very short period of time. But the amount of time that they've taken to perfect that skill is thousands of hours. That goes to say that the people on the other end, like the acting judges and certain types of lawyers, and there are different types of lawyers. And I don't think a lot of people know that. We'll go over that later. Certain types of lawyers, they've perfected the art and the principles when it comes to knowing what these doctrines are. So they're not going to tell you, all right, I'm about to do a fadeaway now. They're just going to do it. And it's going to look so quick that by the time you realize it, you're on your butt and your knees. And everybody's going, oh, did you see that? Yeah. They'll be laughing at you. So know what these principles are, so that when somebody tries to do a fadeaway on you, you probably stand your ground. What are the core of Respondeat Superior? Jurisdictional matter. It's the benefit test and the characteristic test. There's not a national standard for Respondeat Superior because states create their own standard for the doctrine. They're telling you, go to your common law, go to your state's public laws, your session laws of your state. Different jurisdictions will use different tests to prove Respondeat Superior. However, most jurisdictions will use one of the following two tests. However, most jurisdictions will use one of the following two tests. The first test to determine whether your invocation of holding somebody personally liable qualifies based on principles of Respondeat Superior. When the employee's social or recreational pursuits in the employer's premise after hours are endorsed by the express or implied permission of the employer and are conceivably of some benefit to the employer, then that employer is liable for harm resulting from the employee's action. But all that legalese just told you is, at any point in time, if you can somehow link to the fact that the employer benefits from it, then they are held liable, which is called joint liability. Now, what is an example of that so that you could really comprehend that? A cop arrests you and books you. And it turns out that that arrest and those charges and the obtainment of your private biometric copyrighted data and trust property information was obtained under color of law. That machine, that CAB system, and that FBI record, how they cross-reference all that imagery and all those fingerprints that was used to collect your information, the computer that was used to print that police report, the papers that were used to type that complaint to sue you, to charge you with criminal, civil, or misdemeanor charges. Who paid for it? Who owns it? It's not that man or woman who arrested you. That's right, it's their employer. Benefit tests in that situation is concluded and qualifies the moment that man or woman who arrested you and charged you utilized the resource of their employer to satisfy the means of that unlawful authority and that unlawful act. That's just an example. Another example of benefit tests. What if you weren't even arrested? What if it was just for some other stuff? Okay, let's say CPS. They came and took your children, right? Some random lawyer or attorney knocks at your door saying, hey, let me see your children. They do it confidently because they know, well, the average man or woman don't know anything about their rights. The average man or woman will talk about, I have rights, but they know you don't really know it, right? And despite your rights being active at all times, they abrogated on it and took your children and engaged in corruption of blood and forfeiture of state. Your children are your blood. Your children are part of your estate as the father or as the mother or as the legal guardian, whether it's your aunt or someone else who had custody of that child based on the consent of the parent, one way or another, implied or expressed. So they took your children from you. What else are they going to do? They're going to document it. And of course, there's always a lot of perjury and false information. There's always a lot of simulation of legal process. There's always a lot of vexation litigation involved. They're going to say, oh, when I got there, I found the child in an unsafe environment. Of course, to justify their unconstitutional action. Because no one saw it but you, them, and that child, who is not of legal age to engage in contract or testify. So now it's your words against theirs. But they know that they have prestige of an organization who makes multi-trillion, not billion, not million, not six figures, but multi-trillion-dollar business yearly. To create all these instruments to make you look bad, even if it's just one line that you see in the document that they created, that entity that they're working on behalf of, that they use their computer system to create that false report, benefited from it. Because the totality of circumstance points to the fact that they have used the resource and the prestige of that entity that they work for to engage in such unconstitutional act. And by virtue of that, they are benefiting from it. They are being paid based on grants. Yes, there's other things we will speak about. I will show you the grants that each and every state child support or child protective services are getting from a federal and state level. Why? Because they took your children. They're getting grants for that because, well, oh, these children need a place to stay to be safe because their parents weren't fit. So here, take this amount based on the tax of the people of the state of so-and-so and take care of the children with it. So now they're benefiting from it. Oh, and the medium to which they're getting that grant from stealing your children in an unconstitutional manner, the medium they're receiving it is through that entity. That qualifies for benefit tests. Are you seeing how it adds up? But wait, we're talking about entities now, aren't we? Somebody is the chief executive officer, or the president, or the director of all these entities, whether they want to call it mayor, whatever it is. Somebody is the principal. Respondeat Superior tells you a legal doctrine most commonly used in tort that holds an employer or principal legally responsible. And then the example goes on and on and on. If you can invoke one of those basic examples, which is very common, it has qualified for benefit tests. And by virtue of that, your claim of Respondeat Superior is sufficient to state a claim upon which relief can be granted against the head honcho. They tell you, however, most jurisdictions will use one of the following, meaning you just need to pass one of these for you to properly invoke Respondeat Superior. Moving on to the next one. The second test. Let's just say for whatever reason you couldn't find this because your situation is unique, right? It played out in a unique manner whereby none of this occurred. Hey, that's fine. Let's go to the characteristic test. If the employees, meaning the peons' actions, is common enough for that job that that action could be fairly deemed to be characteristic of the job, then the employer will be liable for harm resulting from the employee's action. Benefit tests are usually quite specific. Characteristic test is very simple, meaning were you injured while this man or woman is under the supposition of law? Were you injured while they were acting under call of authority? Yes. Okay, well, then their employer is liable also. It's that simple. So with this, you would not have to look at the specificity compared to benefits test. You will have to be able to prove based on preponderance of evidence beyond reasonable doubt that your substantive constitutionally secured right was trespassed while they were purporting to act under an authority or some supposition of law. Strict liability comparison. A court will choose to apply the doctrine of Respondeat Superior to an employer. The employer could be a natural person or an entity, depending on how you finagle it. Regardless of how closely the employer was monitoring the employee. Oh, wait. So it can even just be a trust relationship. So they cannot use a corporate veil to say, well, I wasn't there. I don't have firsthand knowledge and experience of it. So what you're saying is hearsay and it doesn't apply to me. Remember when we went over the rules of hearsay? That is directly incorporated into the rules behind Respondeat Superior, strict liability comparison, and the exceptions. As such, Respondeat Superior may be compared to strict liability, meaning whatever your employee did, you are evenly liable for it, and you have no way out. What is strict liability? In both tort and criminal law, Strict liability exists when a defendant is liable for committing an action, regardless of what his or her intent or mental state was when committing the action. In criminal law, possession of crimes and statutory rape are both examples of strict liability law. Meaning you don't even have to know about it when it was happening, when it happened, or how it happened. By the mere fact that there's a 6th degree of separation between you and that man, and you're both under the auspice doing business under an entity, oh yeah, you're both liable. Because there's a culture. Whatever you say reasonably is what your employee is going after. Why? Because you're the one calling the shots. Exceptions. Independent contractors. I think this speaks for itself. They're independent contractors. Meaning there's a separate agreement that occurred for them to be able to engage in something rather than being an employee of that man or woman. The third restatement of tort helps to outline the difference between the employee and an independent contractor for the purpose of Respondeat Superior. Respondeat Superior applies to employees, but not to independent contractors. It presents a fairly thorough balancing test, which is the conditions of the contract when it's all said and done. So you can read all this all you want, but the basics and summary of what this list of 1 all the way to 11 is telling you is you have to get an eye on the terms and conditions of the contract that independent, aka private contractor, has with the people who hired him, and in the process of that somehow managed to injure you. Federal employees, aka post office workers, etc. Under the Westfall Act, federal employees will not be held liable for wrongdoings committed during the scope of their employment. But that's not what we're talking about. We're talking about functioning under the color of authority here. So if you want to hold somebody liable using the Respondeat Superior, you better make sure that they've done it personally. And by virtue of that peon, that employee functioning personally and trespassing against you, that leaves an open window to hold his or her boss personally liable. If you play your cards right. And at best, if the CEO somehow bribes the acting judge and gets out of it, whether through association, affiliation, or through monetary interest that you are unaware of, they will throw that employee, that peon, under the bus, and somebody's head will be chopped off. Oh, and also, if you haven't, go ahead to my Patreon and join my Patreon. This is just introductory. The details of how this is enforced and how it's incorporated into the state common laws that they spoke of in here that we went over, and how it's incorporated into the rule of evidence beyond hearsay, and how it's incorporated into judge's handbook, and how it's incorporated into the municipal charters. That I will be going over to the Patreon page. So go ahead and join my Patreon for more deeper details in these introductory information. All these are just introductory, but if you want deeper details on the intricacies of it and on a lot more things, and I also share some documents that I've done, that I've used, and the ones that I'm currently creating, I share with you on my Patreon. So take care and good luck.